this out. So again, thank you very much for attending the December 2nd, 2025 meeting of the Albemarle County Board of Zoning Appeals. I'd like to call the meeting to order and announce the time. It's now 2 p.m. and as the acting chair of the Albemarle County Board of Zoning Appeals, I call the meeting for the December 2nd, 2025 to order. I would like to establish a quorum and ask please that that Ms. Alley call the roll, please.
Ms. Joseph,
Present.
Mr. Rosenberg,
Present.
Mr. Burkhart,
Present. Okay, I'd like to say that we've established the quorum. We have staff. We have the county attorney, Andy Herrick. We have our attorney, Jim Bowling, zoning administrator, Bart Savoda, Francis McCall, police Green back there, I believe I see. Okay. Marcia Alley are all present for the meeting, and will the record please so note that. I'd like to move into the third item on the agenda, which is the public hearing. And before we get into this, I'd like to say that we have received a request to defer this matter until the next meeting, which will be January 6th of 2026. I'd like to ask our counsel if he has any. Yes.
The attorney for the appellant is here.
Yes.
Oh, the attorney is here. Okay, well, pardon me. Welcome.
I'm Maynard Sipe. I represent the Mr. King. I am here today. I made a big effort to rearrange my schedule to be here, which was a little hard. But given that the county attorney objected to the continuance, I felt I needed to do that to protect my client's interest. So I'm ready to proceed today.
You're ready to proceed today. Well, thank you very much for attending. I was basing my comments just before you walked in on correspondence that we received. So thank you very much for.
I just got that, so I'm going to take a moment to look at it.
Okay. Well, thank you. Thank you very much. We are here today for public hearing on project APZ-25-00002, 1701 Old Forge Road. As we go into this public hearing, I will ask the county staff or attorney if they would like to have 15 minutes to make a presentation.
Mr. Chair, members of the board, my name is Andy Herrick. I'm the county attorney here on behalf of the zoning administrator and the board of supervisors. As I had indicated in an email that I sent to, I believe the zoning or to Ms. Alley that was shared with the board, we actually are suggesting that this be heard in three separate parts. The first of which is on the county's motion to dismiss. Second part of which was the motion to continue, although I don't know whether that's still pending. And the third is only if those two motions are overruled would we actually hear the case today. The county filed or is suggesting that this appeal ought to be dismissed on the grounds that no grounds of defense or grounds for appeal were filed with the appeal. And I would point to, and this is pointed out in the staff report as well, the applicable law, this is on page 2 of the staff report, which is packet page 8. The fact that Virginia Code section 15.2-2311A, which governs appeals, provides in part, the appeal shall be taken within 30 days after the decision appealed from the filing with the zoning administrator and with the board, a notice of appeal specifying the grounds thereof. And as you've seen, the appeal that was filed, that was timely filed with the board, did not specify any grounds. So it's deficient in that regard. The county code is similarly structured. County Code Section 18-34.3B. Any appeal shall be in writing and shall state the grounds for the appeal. And again, when this appeal was filed, there were no grounds of appeal filed. And so we would say that the appeal is deficient and should be dismissed on those grounds. If the board should overrule that motion, we of course would want to be heard on the merits of the case itself. But at this point, just preliminarily, we would argue that the case should be dismissed. And I'd like to be heard in rebuttal if the board has further questions. Yes.
Could I interrupt for just a minute? Ms. Alley, are we getting any sound on this mic? You are?
As far as I know, I can hear it and I can hear it in the recorder.
Can the audience hear this? Okay, fine. Okay.
Okay. Thank you. And again, I understand that Mr. Sipe wishes to be heard on this, and I would like to be heard in response to Mr. Sipe's argument as well. Thank you.
Thank you very much. Pardon me. The appellant's attorney, if you'd like to come up, you have 15 minutes, please.
All right, at this moment, since we're bifurcating this motion to dismiss from the substance of the appeal, I'm going to speak just to the motion to dismiss that the county attorney just made. I'm going to be frank, I'm rather taken aback by this motion. I've handled many BZA cases, and I've both as a attorney representing property owners and neighbors in front of a BZA, and as counsel to boards of zoning appeals in 4 other localities in Virginia. I've never heard of this being done. I find it leads me to wonder if the county is very confident in its case. I will say that the appeal was filed by the property owner himself before I was hired. It was filed in good faith. He came to the county in person. He did not feel comfortable submitting the application online as he was told must be done. So he came into the county office, and the staff person assisted him in entering the information and taking the fee for this appeal. I think the staff person was very helpful to him. Mr. King stated that he didn't mention he was not in agreement with the arguments and that he was not using his vehicles for any business use and didn't conduct business on the property. That may not have been entered by the staff person when they entered the information for the appeal. I just now was given a letter that he says he did send to the county, which did state some grounds. Unfortunately, I only have 1 copy with me today. That was sent just by regular mail later or at some point in time. I can't say for sure whether it was received or who saw it at the county, but it was addressed to the county zoning department head. I will say you need to think about the nature of the appeal. An appeal is by right to the BZA. Any property owner who disagrees with the zoning administrator's decision has a right to file this to protect their property rights. I'd ask you to look carefully at the state code language which Mr. Herrick cited in 15.2-2311. It does say, by filing the appeal specifying the grounds thereof. It does not use the word shall, as in shall specify the grounds thereof. It should be viewed as directory and not mandatory. And I'll draw an analogy to that. There was a case not too long ago, which you all may be aware of, where boards of zoning appeals were expected to act on a decision within 90 days. And the Supreme Court of Virginia said, well, the state law says that, but that's directory, not mandatory. Once you have a case in your hands, you have flexibility and some time to do that, to act on it. So not every statement like that is mandatory. I do note that the code section in the county's ordinance inserted the word shall, which of course I would argue is an attempt to go beyond what the state code allows, and is probably not really fair to try to argue the county's creating a tighter rule, since that, in my mind, would violate Dillon's, which I'm sure you're familiar with. I'd also say everything's in place today to hear the appeal. I made an extra effort to be here today so we could resolve the matter. I have parties present. The grounds were provided in a letter I sent that is in your packet now. Hopefully you received that yesterday in advance of the meeting, but I sent that to the Miss Green The public was notified. I imagine there are some neighbors here today who may wish to speak, and I think it would be patently unjust to dismiss it. Thank you.
Thank you very much.
So, Mr. Chair, if I might be heard just for a moment or two in response, I will acknowledge that this is an unusual motion. And the reason it's unusual is that we've never had a case before in which an appellant did not specify the grounds for appeal. We wouldn't be filing this motion if the appellant had timely filed the grounds of defense, the grounds for the appeal as is required, not just by the county code, but by the state code. Again, there is a shall in that code section. The appeal shall be taken within 30 days after the decision appealed from. And one of the things you have to do when you file that is to specify the grounds thereof. This has been found to be mandatory, that numerous cases have been appealed for failing to file within the 30 days required. Now, Mr. Sipe indicated that he had sent a letter to Lisa Green, who's the code compliance officer with the county. Not only was that dated November 21st, so less than 2 weeks ago, it was sent to Ms. Green. It was not filed. Nothing at this point, no grounds of defense have been filed with the secretary of the BZA. The county itself just received this letter within the last 2 weeks. Really, it does a disservice not only to the county in terms of preparing an argument, but also to the board in terms of being prepared to hear the case. I know that the board is eager to hear how the county responds to each point, each grounds of defense that the appellant raises. And if county staff doesn't get that, county staff in its report can address it. It leaves counsel in a disadvantageous position to have to respond to defenses that are just being raised at the last minute. And again, it puts the board in a worse position in that you don't have the opportunity to hear county staff's rebuttal to it. So for all those reasons, we think that this case should be dismissed, again, because the grounds of defense were not timely filed with this case. Thank you.
Mr. Herrick,
Yes, ma'am.
can I ask you if this is dismissed, can the applicant come in with information? And this be reheard at some point in time?
It would not, the Board of Zoning Appeals would no longer have standing for it. Obviously, there'd be a right of appeal there'd be a right of appeal under state law. Staff may work with the property owner in terms of abating a violation, but in terms of this violation, the Board of Zoning Appeals role would be finished if the board were to dismiss the appeal.
So then the dismissal means what? Do we then look at something? There's a page in here, page 42, what happens after the notice of violation that talks about civil penalties?
Right. So the appeal would be finished as far as the Board of Zoning Appeals was concerned. Obviously, we can't address whether the appellant would choose to appeal to the next level. But the board's dismissal of this would allow the county to proceed with civil penalties unless there were some sort of appeal that would stay those proceedings.
And the appeal would go to circuit court?
That's correct.
Okay, thank you.
Thank you. Thank you all.
Yes, sir.
I appreciate the opportunity to speak one more time for a moment. I think the outcome, if you dismiss the case now, to my mind, would be the same as if you uphold the zoning administrator's decision. We would be stuck with a thing decided, and we wouldn't have our day in court, so to say. I also think that it would force us to appeal your decision to dismiss to the circuit court, not the substance of this matter. And that's a big burden and expense on the client. And finally, I think if Mr. Herrick felt he would like more time to prepare based on the letter I sent, I'd be happy to defer it to January 6th if he wishes. But I thought the letter was submitted to the county staff in the zoning department. And as I remember correctly, there's a section in the zoning ordinance that says anything submitted to them will be considered submitted to you. So that's all I had to say on that. But I would hope you would reject this motion. Thank you.
Mr. Rosenberg, did you have some questions?
Mr. Sipe, can you return? I have just a couple of questions. One, so when did Mr. King, he files his appeal in September, is that correct?
Yes.
Okay, September 10th, I'm reading. And so let me see, is that within the 30-day limit after
Yes.
the decision? Okay,
And he paid the fee and he did everything
Right.
that the staff person asked him to at the time.
right. So, okay, so that happened then. Just one other question about some of the things you were talking about.
Mhm.
The comment of Mr. Herrick refers to Virginia Code Section 15.2-2311, capital A, and it specifies the appeals to the Board of Zoning Appeals. And does it or does it not say, and I'm reading from the report, quote, "The appeal shall be taken within 30 days after the decision appealed from." So the time limit was satisfied from what you tell me. From the filing with the zoning administrator and with the board, a notice of appeal, and then specifying the grounds thereof, period, close quote. Do you agree that's the language of the Virginia Code?
Yeah, I mean, I said that earlier. The
Excuse me,
appeals
sir.
shall be taken within 30 days.
Is your answer yes or no?
My answer is yes, that's the
Okay,
language.
thank you. I would like to say, so the county, excuse me for being so rushed, but I'd like to get to the merits of the request here. And the county code, section 18-34.3, small letter B, would you say that it just echoes what you just told me the state code says?
Can you tell me the package
The
page?
section that Mr. Herrick mentioned, 18-34.3, little b,
Is that attached as an
it
attachment?
is attached, any appeal shall be in writing. And you can take a moment and take a look.
Attachment C, D, I'm sorry, I don't know which.
Yeah, it's in the staff response to the appeal, the bottom of page 2 of the staff report.
Page 8 of the packet.
Yeah, page 8 of the packet, correct.
The packet is numbered on the bottom of the packet page. If you can.
Correct.
You're
As
saying
is the
packet page 2?
No. Packet.
Page 2 of the, page 8 of the packet, but
Oh,
page 2 of the
thank you.
document.
Yeah, it gets a little confusing with the numbering.
Yeah, it is. The fourth line up from the bottom.
Yes, the distinction is that the county ordinances, they placed the word shall in front of state the grounds for the
But
appeal,
I
which is
thought
not
you-
in the,
I
which is
thought you-
not
I
the
thought
way
you-
it's worded in the state code.
Well, the state code, how would you say is different?
The state code says is the appeals shall be taken within 30 days.
Wait, you just said the word shall, did you?
Yes, but they're in a different
Okay.
place in the
Thank
order.
you. Thank you, sir. That's all I wanted to know. Let me ask you another question. You raised the distinction between mandatory and discretionary
Mhm.
language.
Directory language, not discretionary.
Directory, okay. Mandatory language, what would you say a statute that had mandatory language meant in terms of the rigor of what it requires?
A mandatory language. Well, you're bringing an interesting point up. I
Yeah,
appreciate
I'm
it.
a law professor. I do this all the time for a
Okay,
living.
I appreciate you bringing it up. Let me pull one of my references. I have it here. I think
I can answer your question if you're having difficulty.
No, I believe that there's several instances in which the Supreme Court has said that the word shall is sometimes mandatory, but other times directory. I gave you one example when application in the Board of Zoning Appeals, where the time frame for you to review a matter, it's been determined that word shall is a directory.
Would you say that exceptional case is the norm or the exception?
By exception, we were talking about
The
Mr. Herrick's
exception.
statement.
Well, no, as Mr. Herrick said, most cases, and I agree with him, read the word shall as mandatory language. And if that is the case here, what does that mean about the specificity of the statutory language, sir?
I appreciate this. I think if you read the state code provision, it says shall be filed within 30 days. I think the 30-day timeframe is a hard cutoff. I think that has been affirmed by the Supreme Court. If you don't get in the door in 30 days, you're out. But I don't think any case exists that says if you file a notice of appeal and pay your fee, that you can be thrown out for not providing the grants.
Even though you're making that argument.
I'm making a distinction in the sentence.
Well,
of the state code.
sir, the statute says at the end of it, and specifying the grounds thereof. You're ignoring that language?
No, I'm making a distinction between the way that language is worded in the state code and the way it has been
Yeah.
reworded in the county's ordinance.
In Virginia, does the state code have a powerful effect on local government's discretion in terms of wording their ordinances? What is Dillon's rule, sir?
Dillon's rule, Dillon's rule says that you can only exercise those powers which have been explicitly given to you by the state or that are implied or otherwise necessary.
Exactly right. And so I'll end my inquiry. I would argue, sir, that first of all, this is language that is mandatory language. The shall applies to both the time limit and the specificity of grounds. Your client and you were probably not engaged at that time, and I don't blame you for this because I'm sure you would have specified grounds had you been engaged. Your client failed to specify the grounds, and my reading of the statute is this is a procedural statute like statute of limitations. Your client has missed the 30-day filing because of the inadequacy of the appeal, and I will vote to dismiss the claim.
I would add, I appreciate your position. I would add that I think there is a reason that the county code was drafted with a distinction in its language. And I think that the county code the county itself maybe had attempted to back up what you've just suggested, that the grounds are mandatory, but by inserting that shall in front of that statement. But they read differently, they're worded differently. I believe that the county code is an attempt to narrow or introduce a mandatory provision where there is not one in the state code. That's my position.
Okay.
And I think it's up to you as a board to decide whether, how you should interpret this, because it's probably, as I think Mr. Herrick admitted, it's a novel thing being raised and a novel point. And I think it's up to you all as representatives of the community and as members who are here to handle appeals from the staff's work and decisions to decide what is the, proper outcome and just outcome for this.
Thank you very much. I'd like to, before we proceed any further into this, and I'll certainly yield to council on this, in terms of the procedural aspects, but I'd like to have a discussion amongst the board members on the issue of whether to dismiss this or not before we move forward. Is that acceptable?
Certainly.
Okay, thank you. I'd like to ask my colleagues here if they have any thoughts on this, because some very interesting issues have been raised, and I think listening to Mr. Rosenberg, I think there are valid points that have been expressed in terms of the failure to submit, according to the staff response to the appeal, any grounds for appeal thereof. Would you care to offer anything, Ms. Josephs?
Mr. Bowling, one of the things that Mr. Sipes said.
Excuse me.
That
Let me just encourage everybody
Sorry.
to speak into their mics.
one of the things that Mr. Sipes said is that if this is dismissed by this board that it would be considered an agreement with what the staff had proposed, that they were in violation.
That's correct.
That's correct?
Yes.
Okay.
And you know, and the statute says what it says, and it doesn't seem to have any ambiguity to me.
Right.
Shall is shall.
Right, and I guess the other thing that I noticed, well, this won't bend, Mark, there we go. The other thing that I noticed in the staff report is that at one point in time, with the so-called application here,
Page
What
21.
page?
page 21, okay, that what I'm seeing in here is a discussion under the note that was created by Mr. McCall. And it says that he spoke with the appellant's attorney and gave him access to civil access for him to upload his grounds of appeal. And the date on that is 10/7/2025. So in October, the appellant had the ability to update the reasons for the appeal. So, you know, there's all this time, we have all these folks here who want to know what's happened, want to know what the argument is, defending the use of whatever is happening on this property, and no one gets that. So it's not something that's good for the community in general to try to figure out and do their own research. It's not good for the BZA to get information a week before the meeting is to be held. And we also do our research. I mean, as staff can tell you that we go through the ordinance, we do interpretations on our own of what the ordinance is. So this is a group that doesn't, unfortunately, I'm so sorry, doesn't always just do exactly what staff proposes. In this instance, they are spot on that we should receive information so that we're able to look at this intelligently and make an intelligent decision. So I can support a dismissal at this point.
Excuse me, sir. I'm in agreement with both my colleagues. I'd like to ask if there's a motion to dismiss at this time.
I move for dismissal of APZ 2025-00002, and it's 1701 Old Forge Road.
Do I hear a second, please?
Second.
Ms. Ellie, will you please call the roll?
Ms. Joseph,
Aye.
Mr. Rosenberg,
Aye.
Mr. Burkhart.
Aye. This will conclude this matter under item number 3. We'll move on in the agenda to the approval of the minutes for June 3rd, 2025. Have my colleagues had an opportunity to review those?
Mr. Chairman, I'm not sure if the public understands what just happened. You might want to explain that.
Yeah.
Oh, I'm sorry. We're just kind of running through this. We took a motion up that would dismiss, which means essentially as you heard my colleague and Mr. Bowling say, this essentially upholds the determination by the zoning administrator in this issue.
Correct.
So this matter has been decided. And I want to thank all of you for showing up, the applicant and his attorney for showing up, as well as county staff for being here as well. So if you'd care to sit and listen to the rest of this meeting and find out what we do, you're welcome to do so. Otherwise.
Can I add one more thing? If I may add, this is not necessarily the end of the matter. As Mr. Sipe knows, the next step would be to file a lawsuit in the circuit court. I believe that's where it is, where jurisdiction lies. And he can take the matter up and before a circuit court judge. But that is, expensive and time consuming. What I would admonish the property owner to do is to perhaps work on some of these violations with the county and to, do the kinds of things that needed to be done probably a long time ago. This is a neighborhood, I've never been there, but from the photos and from the description, it's a very nice neighborhood. And, I'm sure you'd make your neighbors who feel a strong sense of place with that location happy, and you probably would make yourself happy by having a better, higher quality property without large trucks and other debris. And so I would just advise you work with the county and work with your neighbors to make things right.
May I be recognized?
Procedurally, after we've had this, this matter, can we
Anything more?
have the appellant's attorney make a closing
Yeah, if
statement?
you
So
would.
that's
That's up to you, Mr. Chairman.
I would,
Yeah.
yes, I will welcome that. Thank you.
I'm going to greatly appreciate being recognized because this is sort of a novel issue. I appreciate you recognizing me one more time. I do want to add that I mentioned it in my argument, but didn't really emphasize it, that my client did provide me with a copy of a letter which he did state his grounds of appeal, which was filed by him prior to filing the appeal. As a layperson, it's difficult to expect them, a property owner or any other citizen, to follow this process. And I'm going to ask if you would at least consider a motion to reconsider your action and to accept evidence on this letter that was submitted by my client.
What I'd
I
like,
think it would just lead us to a more just result here and be able to air the issues since everyone is present for this matter today. Alternatively, if you did reconsider, we could carry the matter over to the next meeting date and then have a full hearing.
Mhm.
But I think it would be more just to have a full airing of this matter rather than not. Thank you.
Mr. Chairman, if the appellant applicant wants to bring a further motion before you, my recommendation is this case is over and it should be done in writing and
yes,
with time and to consider that matter at a later meeting. But this
Yes.
case has been decided.
it has
as I
been decided.
understand.
Yep.
So my understanding is a motion to reconsider is proper, one of those voting in affirmative
I
for the,
I didn't say
debate.
that, sir. I
makes
said
the
that
motion.
If you wish to present.
And it
a
could carry
motion,
over to
you're
another meeting.
Certainly free to do so.
Yeah, the board is free to do so, and it could be carried to another meeting if you wish. Thank you.
Thank you.
Can I yield to Mr. Rosenberg?
I agree with counsel that if there is a formal request, it should be done in a formal fashion and in writing, so we could, with grounds to be supplied, so that we make a complete request understood and understandable to both the county staff and to the board. We only have 3 of the 5 of us here, and so to persuade maybe the other 2 of the merits of a reconsideration, because I don't know enough more information to make me think that this deserves it. So do it in writing and do it carefully and thoroughly. Move on.
We have a member of the public that would
Oh,
like to
yes.
speak.
Yes, there's a gentleman here.
Yes, sir. Please step forward, state your name and,
Identify yourself.
yes.
Thank the board for listening to me for just a minute. My name's Ed Basham. I'm a property owner in the community. This is not the first time that this problem has been in front of you all.
Right.
And with no malice, of course, to Mr. King at all. But the fact is, this is a very nice neighborhood. There's 54 homes. The average tax assessment's a little over $750,000. The homes were built in the late sixties and early seventies. They're all well cared for and maintained. And it's a very tight, close-knit neighborhood. It's a pleasure to live there. The real issue, in spite of all, and I'm not an attorney, don't profess to be, all the legal details that have been argued here, the bottom line is that Mr. King has this morning a ditch witch trenching machine, a very old medium-duty truck chassis, a very old medium-duty dump truck, several trailers, a snowplow, which none of these vehicles have the snowplow attachment on it to operate it, and some other smaller debris. I think the real issue is to get this debris off the property. It doesn't belong there. It hasn't been moved for months, in some cases years. The snowplow's been there as long as I can remember. So really do all the details. This needs to be resolved. And the other thing, the fines are somewhat incremental. Realizing the cost of property and leasing rates in this area, it will cost Mr. King more to rent a lot to store this property than the fines are. So he has no real incentive at this point to move the debris away. So I appreciate you hearing me. I know you've made your decision and I appreciate that. And I hope you all have a good day.
Thank you.
Thank you, sir.
Thank you.
Yes,
Mr.
you may,
Chairman,
if you
Mr.
introduce
Chairman,
yourself. Yes,
Mr. Chairman,
yes.
could I be heard? There's some benefit for finality, and what we have here is a continuation of a hearing in which you've made a ruling.
I
So
agree.
you may want to consider that and how you
That's
want to
fine.
proceed from this
Oh,
point.
okay. Thank you very much. We have made our decision. I will follow the advice and that Mr. Rosenberg gave to council, that what you said previously. And so did you want?
I just want to say thank you so much for all the emails, and we do read them,
Yes.
really and
Yes.
truly. So thank you for doing that. Thank you for coming out, because I know it's not easy to just disrupt your day and show up to these meetings. So thank you so much.
Thank you. Okay, we'll move on in this meeting to item number 4, approval of the minutes for the June 3rd, 2025 meeting. I assume my colleagues have had an opportunity to read these. Are there any changes or additions that either of you would care to make with what's been presented?
I have none.
I'm going to take it on faith because I wasn't there. So,
Yeah,
but I can vote on these, just so you know.
okay. I will ask a motion to be made to accept the minutes, please.
I move we accept the minutes for June 3rd, 2025.
And a second, please.
Second?
Okay, Ms. Alley, will you please call the roll?
Mr. Rosenberg,
Aye.
Ms. Joseph,
Aye.
Mr. Burkhart.
Aye. Okay, a vote of 3-0. The motion carries for approval of the minutes of the June 3rd, 2025 meeting. We're going to move on to old business.
Mr. Chairman,
yes,
before
yes.
you do, I sent you an email this morning, and I'm going to leave for the reasons
Right.
which I've already talked about.
Yes, sir.
If that's acceptable, and I
That is
apologize
acceptable.
for any inconvenience.
Thank you.
And I hope your partner is in good shape.
I hope so too.
Okay, we'll move on to old business. There's currently no old business on the agenda. I'll ask with my colleagues, is there any old business for discussion?
I would just like any information that you guys have on the gun case. Is that still going on? Are we, what's happening with that? Do you?
I think you've gotten the answer. The same answer is probably going to be given that we defer to Mr. Herrick on that one, but we have not heard anything new.
Okay.
Nothing to report on that.
The
Gun
gun
case.
appeal. Yeah.
No news. Okay. Thank you.
Thank you very much. Is there any other old business that we need to discuss? Mr. Rosenberg, anything?
No, no all business.
Okay. Going on a new business, we have the BZA annual report. I assume everybody's had a chance to take a look at that.
Mhm.
Okay. Were there any notations that, I know that it's already been submitted to the Board of Supervisors, correct? So are there any amendments, any additional comments that should follow? I guess not. I don't have any. Budget discussion is the next item. It's been conveyed to me that that there will be $1,000 increase in the FY 26-27 budget for BZA legal counsel, bringing that line item up to 6,000. Is there any further discussion about budget and what lies ahead? And maybe we could get an update from the zoning administrator on that in terms of the timeline and any inputs that we might want to have as a BZA into that.
So Bart Swoboda, zoning administrator, Albemarle County. We talked about that early on in the process so we could make sure that we got the request in this year. It was added to the budget. We are in the county itself is in the beginning of the budget cycle. So it won't be until January sometime where they start to really dig into it after it gets through finance and recommendations from the finance department to the board. So once the budget hearings start after the first of the year, that's when we'll know more. So it's kind of a hurry up and wait scenario for us when we start talking about budget in August, September, and then we turn our stuff in and the process kind of plays out after the first of the year.
Well, I'm still concerned about the lack of alternates on this board. I think for any hearing, I think to give the benefit to the public, to the county, to the BZA, to the appellant, I think it's always good to have a full board seated at every opportunity. We've talked about this now for well over 2 years. At what point in the budget presentations would you suggest in January that we come before the board to ask for funding? And again, it's minimal, at $85 a meeting, and we've had only a couple of meetings this year. My gosh, for a couple $100, we could have an alternate funded. And I think that the Board of Supervisors, especially with 2 new members coming in, may not fully grasp the importance that this body has in the cog of economic development within the county. So I think that, 1 or 2 of us would like to come before the Board of Supervisors at the appropriate meeting time to be able to make a pitch for that, because I think it's important, and I would like my colleagues to chime in on that if they so wish.
I plan to go to one of the board meetings at their 3 minutes in an item that's not before the board and remind them that we asked them to do something, to take action, and we were ignored pretty much. So I think that comes along with discussion on the budget. And what Kurt's talking about with economic development, I mean, it's really important for this group to do what we do. I mean, we're people in this audience, we're talking about the value of their properties. And if we don't do our job, then who's going to want to bring their company here and who's going to want to live here? So I think part of what we do is to maintain the character according to the zoning ordinance. So I really think that the new members of the board, I'd be very happy and willing to talk to them about what our role is, how important it is, and it's something that the state code is really encourages in localities. So just kind of just so that you guys know what's going on, because I plan on going, and I plan on asking Kurt to go with me because he's the one, he and I did the research, and he can always, stuff a sock in me if I'm going to saying more than I should be saying. So, anyway, just so you know, guys.
I can inquire on what a best time or best venue is for that if you wish. If not, I'll leave it to you.
No, it's gonna be a surprise.
Okay.
I.
Fair enough.
Yeah.
Can I add something? Are there new members to the Board of Supervisors?
Yeah.
Of the five?
Yes.
There'll be two.
There are two new ones. Here's something I'd suggest, and maybe this is separate and apart from this budget request, is what you were saying. Sometimes new people don't really understand the functioning of the different parts of this land use system. And I'm not saying take a lot of time with them, but do something to explain to them what the BZA and, maybe the Planning Commission wants to do it too, to kind of just explain to the new members and maybe to the existing ones too, in 5 or 10 minutes, what we do and why it's significant, and, just to make a short presentation, and maybe Kurt, would be the one, but because a new person might know about economics or taxes or something, but not know anything about land use regulation at all. So,
We have one, Fred Missel, who's been around for a long
okay,
time. And he's landscape architect, and
he probably
he's been,
knows,
yeah, and
The other one,
he's been on the Architecture Review
Uh-huh.
Board, he's been on the Planning Commission.
So
So
he-
Fred,
yeah.
Fred knows what's going on, and I don't know who the
other
other
one
new
is-
member is.
the fifth one. Well, in any case, if it's perceived to be unnecessary, then let it go. But,
No, I don't think it's unnecessary. I think it's really important because I think that the experience we had with the other board was obvious to me that they did not realize what the heck
what
we
was
do.
going on,
So I think that it's important for not just the new members. I think
For the
it's
existing
important
ones.
that everybody sort of gets a refresher course on how these different agencies work.
Right, I agree.
So I'm with you.
Okay. Anything more?
I have nothing more to add on that. The next item is upcoming meeting information. So I'd like to ask, what are we expected to see in January other than the annual organizational meeting?
We do not have anything filed as of yet, and I don't think we would expect, I believe it's already passed any
Yeah, the
kind of
deadline,
appeal
yeah.
deadline to have anything like a variance or a submittal deadline for a variance or an
Okay.
appeal.
Well, thank you.
I would like to add something to that topic. I would like us to have a discussion about the application process, because it was totally unclear to me what page the application was. I didn't see any kind of signature from the applicant. It was just kind of wifty. In the olden days, there was a paper copy and the applicant signed it, and there it was. And it was very clear to the applicant that they had to submit that information within that time frame. So I really think we need to talk about that so that we make it clear to the applicant what needs to happen.
Yep, and we've heard that already.
Okay.
And we believe that with the new system, which is, it's still in its infancy, even though it's almost a year old, but we're dealing with that. That's how we've had to process that. So yes, we're fully aware that with a number of applications that we do have already, and we've been making adjustments all year long as far as for different things. And this is just one of them that we need to do that with. And as you know, as Bart, I know, or somebody had mentioned, we don't usually come here and hear the appeals that often. So it's
Right.
Right.
that submitting that online and going through that process.
Well, what really got me going was listening to the appellant's attorney say that staff helped write the application. And I thought, whoa, this is not a good thing, because if that's happening, if it's so complicated, that staff has to help. I mean, they're going to use that sort of argument. And I just think it needs to be very clear what's going on with the application
And,
itself.
and not to make any excuses, but there are certain constraints that we're just dealt with the system that we'll figure out and see if we can figure the way around to make sure that it's, because that's what we're here to do. We're here to help. And that's why, the staff member helped Mr. King when he did come in. And we have that opportunity when those two were
Right.
very.
So
And there needs to be some sort of affidavit or something that says, yes, staff helped me, but those words are mine. I mean, it's just, I mean, I just thought, uh-oh, you're opening the door for
Yeah.
something here.
Good idea. Yeah.
Something.
Can I ask Mr. Herrick a question, please? Mr. Herrick, this fact pattern was kind of the nightmare scenario of poor maintenance of a residential lot with all the pictures and descriptions. I was wondering, ordering the owner to do something is one thing. What is the progression of enforcement, just so we would know what would happen afterwards?
So typically on appeals or on notices of violation that aren't appealed, they do become things decided. They're typically taken to the general district court on
Okay.
warrant and debt for civil penalties.
Okay,
With the first civil penalty being $200, subsequent civil penalties, which can accumulate every 10 days at $500 for a maximum of $5,000 of civil penalties.
tops. Mhm.
And in addition, with every additional court order, we can order the violator to abate the violation.
Right.
For the rare property owner that gets that $5,000 cap on
Right.
civil penalties, it can then be a criminal enforcement.
Oh, really? Well, yeah.
So there's a variety, and again, even that's the typical route that's taken on unappealed notices of violation or notices of violations whose appeals are exhausted.
Does the county have the authority, after it seeks compliance, to take action and then seek reimbursement for the action?
That's also a possibility. It's not one that's often taken.
Yeah, because, you know, I think a non-cooperative property owner or someone who's not around and doesn't care, you know, because the months that passed, you know, the staff was, I think, very understanding in my, you know, maybe I'm a little too, you know, obsessed with compliance, but you seemed to wait long enough and you gave him the opportunity to do, if it takes time to hire people to move stuff or whatever. And I was thinking at some point, I guess the county might say, we'll do it and we'll impose a charge. And if you don't pay, we'll secure it as a lien to your title or something.
And that's a tool in the toolkit, but again,
Yeah.
one that's not
That's
very.
an extreme. Well, I'm talking about a rather extreme situation where there's a serious health and safety,
Right.
you know, problem. What if that was a storage truck of nitroglycerin? You know, I'm giving a hypo, but it's.
yeah, there's different scenarios that we would pursue different things.
Yeah.
So to the CCO's credit, the code compliance officers credit,
Yeah,
we do
yeah.
over 300 violations a year.
Yeah.
Right, to have 1, 2, or 3 of them appealed to the BZA a year is pretty good, and to have a success rate of
Right.
cleanup, because our goal is compliance, not penalty.
Is high.
So
yeah.
if I have to get you to spend $1,000, I'd rather have you spend it hauling stuff to
On-
the dump than
Sure.
paying a fine. And so
Sure.
in these rare occasions where we do need to take folks to court, to
I know
help
it's
motivate them.
an unusual situation, but I just was thinking, what if it's, you know, are there emergency powers if it's a serious, you know, nitroglycerin is a ridiculous example, but you get my drift. If there's something that could contaminate water, if it was acid or something that got on the ground or something like
Yeah,
that.
in those scenarios, that's going to be more probably in our emergency services, right? So if something happens there, either health department, fire rescue, PD, or a
But
combination
before it
thereof.
happens,
Well, and the other partner that Mr. Swoboda neglected was the building official. Oftentimes, it's a building or structural problem, you know,
Yeah.
structure's in danger of collapsing. We can involve.
Yeah, but what if it was something that was carted on like these trucks that was a tanker? I mean, I'm imagining a worst case scenario and the tanker had residual acid or waste or petroleum or stuff. And it was sort of abandoned, you know, so it hadn't happened yet, but there was a risk of if it,
Yeah, an abandoned vehicle, we would probably do a joint investigation with PD, fire department, the necessary agencies, possibly DEQ.
State
Yeah,
agencies.
yeah,
But-
and identify what that is and then what
What
the
needs to be
severity
done.
is and how it handle it, yeah.
I have a question for you. I was intrigued in this, in this report. How does a commercial dump truck, which is what one of those vehicles is, okay? How does a truck that may have had a commercial life to it previous get antique tags? I've looked at the DMV code and it is not for commercial vehicles.
Okay.
So I'm just wondering, how did that slip through other than, was it an error at DMV? Was it intentional? I mean, I'm curious. How does that happen?
I don't know off the top of my head, and I'm hesitant to get into the
I'm
underlying.
just curious, yeah.
I understand, but I'm hesitant to get into the merits of a case that's been dismissed, and I don't know the answer off the top of my head.
We could speculate a lot.
well, you know, this was an interesting case in that I think the people who were here and the fact they showed up, they cared a great deal about that this be rectified. You know, we're in an age where sometimes conflict results, and I wouldn't want someone to get into a conflict situation with the property owner over the property owner is not doing something, because in this day and age, I can imagine all kinds of pretty bad scenarios. So, do you know why the owner, Mr. King, didn't do anything?
So again,
You have no
I
idea?
would prefer to stay away from a discussion
Okay,
of the merits of the
okay,
case, given
fair
that it's
enough.
been dismissed.
No, okay, well,
And I would remind, again, I'm not counsel for the BZA, but I would remind you that you are still on
Sure.
the record and that the transcript
Okay,
of this may be
okay.
used in
how often does something like this happen? Is this once in 5 years? Is this once in 1 year? Is this once every 6 months?
when you say how often does this happen?
A fairly serious, what I find serious is both the trucks that were commercial trucks and the debris, that the description of the debris. Is this common or is this uncommon?
So Bart Swoboda, zoning administrator, it's not uncommon. This is not the worst violation we've seen. It's also not the simplest, right?
Okay.
But it's kind of middle of the road, and when we have evidence for folks, we work with them and we get them cleaned up. So, you know, if we able to reach that understanding with folks, there's a time period and we help, you know, folks gain.
And do they usually take action when you get into this conversation with them?
Yes,
Most of the time?
yes.
Okay, so this is unusual in that this
It's,
occasionally does not happen that
yeah,
way.
it's unusual that it comes to the appeal stage. I would say it's not unusual that we end up in court, but it's also doesn't happen with every violation.
Right, of course.
Right. So there's a small percentage of the overall 300 that actually end up in court. Usually those, and Mr. Herrick can either correct me or back me up, they tend to be the same folks
Over and
that
over.
take a little while, a couple of trips to general district court to understand that we mean business, and then things get worked out.
Let me interject here that we were under agenda item 6C for upcoming meeting information. I think we've kind of like,
Yes.
I think we've had a little creep here, so I'd like to stick to the agenda, please. Thank you. If there's no further information about upcoming meeting at the information about the January 6th meeting, I would entertain a motion to call this meeting of December 2nd, 2025 to a close. Do I hear a motion?
I move for adjournment.
Second.
Will you please call the roll?
Ms. Joseph,
Aye.
Mr. Rosenberg,
I
Mr. Burkhart.
Aye.
Thank
Thank you
you.
very much for attending.
Nice to see you all. Been a while. Okay.
We were getting into